Hello everyone, welcome to Courts Today by Livelaw, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Let us start. Starting with an important update where the Supreme Court has today ruled that bar councils cannot collect enrollment fee more than the amount specified under Section 24 of the Advocates Act. The Advocates Act of 1961 prescribes the enrollment fee payable to the State Bar Council as Rs 600 and Rs 150 towards the Bar Council of India for advocates belonging to the general category. For advocates belonging to SC/ST categories, the amounts are Rs 125 respectively. But in some states, the enrollment fee goes to the extent of 40,000 rupees. Thus, various petitions were filed in the Supreme Court challenging the different enrollment fees being charged by different state bar councils as exorbitant. The bench led by CJI D.Y. Chandrachud and comprising Justices J.B. Pardiwala and Manoj Mishra has now held that since the Parliament has specified the enrollment fee, the bar councils cannot violate the same. As the Parliament has stipulated the amount in the exercise of its sovereign power, the state bar councils or the Bar Council of India, being delegates under the statute, cannot alter the fiscal policy laid down by the Parliament. The judgment states that charging exorbitant fees as a precondition for enrollment creates barriers, especially for those belonging to marginalized sections, to pursue their profession. At the same time, the court declared that the judgment will have a prospective effect only, meaning that the bar councils are not required to refund the enrollment fees collected in excess of the statutory amount so far. The court also clarified that the bar councils are at liberty to fee other charges for the work they do for advocates, but they cannot be levied as enrollment fees. A public interest litigation has been filed in the Delhi High Court seeking constitution of a high-level committee to probe the recent basement tragedy in city's Rajendra Nagar area where 3 civil service aspirants lost their lives. The 3 aspirants died in a flooded basement at Rao's IAS coaching center on Saturday evening. The plea was mentioned today by Advocate Rudra Vikram Singh before a division bench comprising Acting Chief Justice Manmohan and Justice Tushar Rao Gadela. The bench said that the matter will be listed tomorrow if the plea is in order by 12:30 p.m. today. This PIL seeks constitution of a district-level committee in each district of the national capital to investigate and find out the illegal commercial construction in their respective districts. It further seeks a direction on the authorities to submit the action taken report as per the directions issued by a coordinate bench in relation to the fire incident in coaching center in Mukherjee Nagar. The plea also seeks constitution of a committee to probe and compile the report of the coaching institutes which are running in an illegal manner and not following the standard norms. Let me tell you, Delhi Lieutenant Governor Vinay Kumar Saxena has announced 10 lakhs as compensation for the kin of the 3 deceased civil services aspirants. The LG further assured action against the erring officials of Delhi Fire Services, Delhi Police and the Municipal Corporation of Delhi within 24 hours. In a landmark judgment, the Telangana High Court has affirmed the right of women belonging to the Akbari sect of Shia Muslims to conduct religious activities in the Ibadat Khana located in Darul Shifa, Hyderabad. The ruling came in response to a writ petition filed by Anjuman Alawi Shia Akbari Registered Society challenging the denial of access to women for conducting majlis, jashns and other religious prayers in the premises. The case originated from a long-standing dispute over women's access to the Ibadat Khana. The Petitioner Society had previously submitted multiple representations to the Telangana State Waqf Board in October 2023, seeking permission for Shia Muslim women to conduct religious activities. However, receiving no response, they approached the High Court for relief. In December 2023, the court initially heard arguments and passed an interim order directing the respondents to permit the women to conduct religious activities in the Ibadat Khana. This order was challenged by the Mutawali of the Ibadat Khana, who filed an application to vacate it along with a counter affidavit. The petitioner's counsel, Senior Advocate P. Venugopal, argued that denying access to women violated their fundamental rights under Articles 14 and 25(1) of the Constitution, guaranteeing equality and freedom of religion. In opposition, the Waqf Board's Standing Council contended that religious sentiments and conventions should be respected. However, they were unable to provide any specific religious text prohibiting women's entry into prayer halls. Justice Nagesh Bhimaka, in his judgment, has relied on several key considerations. He cited the Supreme Court's landmark Sabrimala temple case, which upheld women's right to enter places of worship. The judge noted that the Holy Quran does not prohibit women from entering prayer halls except during a specific period. He also highlighted that the Waqf Board had previously permitted Shia Muslim women to enter the prayer halls, making the exclusion of the Akbari sect discriminatory. The court emphasized that Article 25(1) of the Constitution confers on every individual the freedom of conscience and the right to profess, practice, and propagate religion without any distinction. While acknowledging the pending case before the tribunal, the judge asserted that the court's power under Article 226 to intervene in matters involving fundamental right violations. In conclusion, the High Court has allowed the writ petition upholding its interim order of the year 2023. The Supreme Court has scheduled for hearing the election disqualification petition filed by Shiv Sena Uddhav Balasaheb Thackeray faction against the MLAs of the Eknath Shinde faction for 7th August. This petition, filed by the UBT member Sunil Prabhu, challenges the Maharashtra Legislative Assembly Speaker's order of 10th January this year, dismissing the disqualification petitions against the Shinde group. Senior Advocate Kapil Sibal, representing Prabhu, today requested clarity on the listing, highlighting that clubbing of the Shiv Sena UBT case with the NCP case, which is set for September, could delay the hearing. Yesterday, the court had actually tagged the petition by the NCP Sharad Pawar, challenging the Speaker's refusal to disqualify Ajit Pawar's NCP faction with the pending Shiv Sena UBT's challenge. The Chief Justice of India, D.Y. Chandrachud, addressing Senior Advocate Kapil Sibal's concerns, today clarified that the matters would be heard together on 7th August. During the hearing of the Patanjali misleading ads case, the Supreme Court today was informed that the sale of 14 Ayurvedic products by Patanjali and Divya Pharmacy, for which licenses were earlier suspended by the Uttarakhand government, is continuing. During the hearing, the counsel appearing for the petitioner, that is IMA, submitted that 14 medicines are available over the counter, even though Patanjali had earlier reportedly stopped their manufacturing in view of the suspension of relevant licenses. Patanjali then stated that the suspension order was cancelled by the state government on 1st July after considering a report submitted by a committee constituted to look into the matter. Thereafter, Uttarakhand government issued a fresh notice to Patanjali, pursuant to which it entered appearance on 18th July. However, the decision was now pending with the state government. Considering the submission, the bench of Justices Hima Kohli and Sandeep Mehta directed the Uttarakhand government to take a decision on this issue within 2 weeks and communicate the same to the court. In another update, the Supreme Court bench of Justices Bela M. Trivedi and Satish Chandra Sharma today granted bail to Trinamool Congress leader Anubrata Mondal in the case registered by CBI in relation to an alleged India-Bangladesh border cattle smuggling scam. While granting bail, the court said that the trial was unlikely to commence soon. Anubrata Mondal, a prominent leader of West Bengal's Trinamool Congress and Birbhum district president of the ruling party, is one of the accused believed to be involved in a multi-crore cattle smuggling ring, which allegedly involved smuggling cattle to Bangladesh through Birbhum. His counsel, Senior Advocate Mukul Rohtagi, today argued that they are yet to receive the English translation of documents, including the charge sheet. He said that the documents are in Bengali and run into 1,000 pages. Additional Solicitor General S.V. Raju, opposing the bail, told the court that Mondal could influence the trial. In response, Rohtagi argued that he has been in jail since August 2022 and had suffered prolonged incarceration. The court, while granting bail, has imposed bail conditions on Mondal, including that he must surrender his passport. He is also directed to cooperate with the trial proceedings. Mondal was arrested by SEBI in August 2022. This year in January, the Calcutta High Court refused to grant him bail in the case lodged by the CBI. Later, he was shifted to Tihar jail in the national capital, where he is currently lodged. Let me tell you, though the court has granted him bail in the CBI case, he will remain in jail as he was arrested by Enforcement Directorate in November 2022, which is also investigating the matter along with CBI. The Supreme Court today granted bail to Ram Kripal Meena, who is accused of leaking and distributing question papers of the Rajasthan Eligibility Examination for Teachers 2021 for a payment of 1.20 crores. He was granted bail in the case under Prevention of Money Laundering Act in relation to the paper leak. The bench of Justices Surya Kant and Ujjal Bhuya was hearing his challenge to a Rajasthan High Court order denying bail when it noted that he had spent over a year in custody and the only predicate offence against him was under Section 420 of the Indian Penal Code. It was further observed that he had already been granted bail in the predicate offence and that ED's examination of 24 witnesses would take time. Therefore, the court said that rigors of Section 45 of PMLA could be relaxed in this case. In an important update, the Kerala High Court has held that cartoonists, being a part and parcel of the press and media, are entitled to freedom of expression guaranteed by Article 19(1)(a) of the Constitution. The court thus quashed proceedings initiated against the printer and publisher, editorial director, managing editor, editor and chief editor of Kerala News Daily Malayala Manorama under Section 2 of the Prevention of Insult to National Honour Act of 1971. Justice P.V. Kunnikrishnan was dealing with an application to quash the FIR against them for allegedly insulting the national flag. Let me tell you, Malayala Manorama, in connection with the 70th Independence Day celebrations, published a caricature depicting Mahatma Gandhi and the Indian flag, with the top side of saffron portion of the flag outlined with a black line. The complaint was filed against them by the Area Committee General Secretary of the Bharatiya Janata Party. So they approached the High Court seeking quashing of the FIR and the final report. Malayala Manorama contended that it had a tradition and they would never disrespect or dishonor the national flag or Mahatma Gandhi. It was stated that the cartoonist was expressing his freedom as an artist to celebrate Independence Day by using a caricature. The court stated that the term insult is an essential ingredient to attract an offence punishable under the Prevention of Insult to National Honour Act. And as the term insult was not defined in the Act, the court must refer to its ordinary meaning. It stated that insult is generally understood as derogatory or demeaning remarks, comments or actions intended to offend or humiliate someone, undermine their self-esteem, provoke anger or hostility, or display contempt. The court stated that Malayala Manorama had no intent to insult the national flag or Mahatma Gandhi. It appreciated the cartoonist and stated that the caricature depicts a beautiful picturization of the 70th independence anniversary. The court went on to say that the complaint was filed without considering the positive impacts of the independence anniversary celebration edition of the newspaper. As such, the court allowed the petition and quashed the proceedings against the petitioner. The Supreme Court bench of Justices Bela M. Trivedi and Satish Chandra Sharma today allowed Aam Aadmi Party MLA from Punjab, Jaswant Singh, to withdraw his plea challenging his arrest by the Enforcement Directorate. He was booked under the PMLA for allegedly being a director and guarantor of a company, TCL, which had obtained loan and credit facilities of over 46 crores. The amount is alleged to have been diverted to other companies against the terms and conditions of extending the credit facilities. Also, a sum of 3.12 crores is slated to have been diverted into the personal account of the Aam Aadmi Party leader. The court has now given him the liberty to move the Punjab and Haryana High Court. This comes after the High Court in May dismissed his plea challenging the legality of the arrest. Singh had contended that the material in possession against him, including the memo of arrest and the grounds of arrest, had been sent to the adjudicating authority under the PMLA 2 days after the arrest, whereas it should have been sent immediately. But the High Court had stated that under the PMLA, it was nowhere specified that the material should be sent on the day of the arrest, as the term used is immediately after arrest. I must also tell you that on 29th May, the Supreme Court had refused to grant ex parte interim bail to Singh to campaign for the ongoing Lok Sabha polls without hearing ED's arguments. In the next update, the Supreme Court bench led by Justice Bela M. Trivedi has dismissed a plea challenging FIRs against gangster Lawrence Bishnoi. These FIRs were based on the Punjab and Haryana High Court's direction following an investigation by a special team. The team was formed to investigate how Bishnoi, while in high security Bhatinda jail, managed to give 2 interviews to a private TV channel. The interviews, reportedly recorded over a video call, raised concerns about inmates using mobile phones in jail. Bishnoi is facing charges in the murder of Punjab singer Sidhu Moosewala, which took place in May 2022. Punjab police had alleged that Bishnoi had plotted the murder in Tihar jail, where he is serving jail under the Maharashtra Control of Organised Crime Act. He has approximately 57 FIRs registered against him. He is currently lodged in Sabarmati jail. A plea-seeking probe into the interviews taken of Bishnoi was dismissed as withdrawn before the Punjab and Haryana High Court last year. In an official statement, the Punjab DGP had claimed that the interviews in question were not recorded inside any of the state's jails. Subsequently, in March 2023, the Punjab government informed the High Court in a PIL that it had formed a committee considering to probe how the interview took place. To read more on this, you can visit livelaw.in. And now let me tell you, the Securities and Exchange Board of India, or SEBI, has imposed a 3-year ban on Vijay Mallya, a prominent businessman and former chairman of the United Breweries Group. This decision bars Mallya from trading in the securities market and prohibits him from associating with any listed company, either directly or indirectly. This decision stems from Mallya's involvement in a scheme to manipulate the Indian securities market through overseas accounts. SEBI's investigation revealed that Mallya used Matterhorn Ventures, a foreign institutional investor, to covertly trade shares of his group companies, including Herbert Sons Limited and United Spirits Limited. The funds for these transactions were routed through various overseas accounts held with a Swiss bank. The investigation, which covered transactions from January 2006 to March 2008, found that Mallya employed a complex network of overseas entities to conceal his identity and influence the Indian market. A Delhi court will hear tomorrow the anticipatory bail plea moved by probationer Pooja Khedkar, accused of misrepresenting and falsifying facts in her application for UPSC Civil Services Examination 2022. Khedkar's story has gone viral on social media. She joined the Pune Collectorate as part of her probationary training in June. The allegation against her is that she misused quotas under other backward classes and persons with benchmark disabilities to clear the CSE. An FIR was registered against her by UPSC in the matter. A show cause notice was also issued to her on cancellation of her selection, and she has been barred from future examinations. She has also been booked by the Delhi Police's crime branch for allegedly submitting false information to UPSC about her identity to avail more attempts at the civil service exams than she is eligible for. The matter was today adjourned at the request of the additional public prosecutor on the ground that the state had appointed a special public prosecutor to argue the case. The counsel appearing for Khedkar informed the court that with each passing day, the IAS officer was losing her opportunity to respond to the show cause notice issued by UPSC. Eventually, the additional sessions judge Devinder Kumar Jangla of Patiala House Courts adjourned the matter, which will be now heard tomorrow morning. Stay tuned. And lastly, a Delhi court has sentenced a man to 1 year of simple imprisonment for throwing acid on a dog, resulting in the loss of one eye in 2020. The case was registered by the owner of the dog. It was her case that she had seen the convict throwing acid on the eye, face and other body parts of her dog. She alleged that when she was giving a bath to the dog, the convict started abusing her and threatened to kill the dog. Convicting the man in the case, Additional Chief Metropolitan Magistrate Richa Sharma observed that the prosecution established his identity beyond all reasonable doubt and further proved that he caused injury to the dog. The court awarded 1 year of simple imprisonment to the man along with a fine of Rs 10,000. However, the court admitted him to bail for 1 month in order to enable him to prefer an appeal against the conviction and sentence. The court significantly said that life is as dear to a mute creature as it is to any human. A human being is expected to remember that his action towards animals reflects humanity and that it is our responsibility to be compassionate and kind to animals. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.